Welcome back to the 8-Figure Attorney Podcast. I'm Seth Bader, and I'm so excited to introduce our next guest. She is the founding partner of Shamp Silk Trial Law Firm, and she herself has collected millions of dollars in verdicts and settlements for her clients. She is Laura Shamp, and I'm so excited to introduce her. Welcome.
Okay, great to be here.
How are you?
Good.
Good. So, talk to me. Competitiveness. You're a competitor, aren't you?
I am.
And
yes.
and I noticed in preparing for today's podcast that you actually took your team to the Final Four back in the day.
Back in the day.
So you've been a competitor for a while.
Yes.
So let's talk about that. Let's talk about.
And I understand you were a basketball player in college.
Not in college. No, I played in high school.
Oh, okay.
But I played sports for a while. Loved to compete. Loved sports. But no, I did not make it quite as far as you did. So, but talk to me about the Final Four. I don't know when you last had a chance to go back and share that story, but I'd love to hear that. I think this is the first time I've actually had a trial lawyer on here that made it to the Final Four. Probably the only one.
Now let me clarify. It is Division II. We were D2 Final Four, okay. But Mercer it was Mercer University. It's a Division I school, mm-hmm. Division I program, and I credit competitive athletics as being sort of part of, I think, what's made me a successful trial lawyer. I think that the idea of hard work, the idea of, accomplishments come from, doing the work, putting in the time, putting in the effort, and then you can have success. So I really credit that time and, coaches who worked with me, teamwork, which it takes, as you know, to be a good lawyer, to be a good trial lawyer, all of those things. But we played, I played women's basketball a long time ago. The women are much better now than I was then. But we had a great run, a great season. We ended up playing in the Final Four. We lost, of course, in the first game of the Final Four, or I would tell people that I played in the national championship.
Sure.
But it was a wonderful experience. Made great friendships and learned a lot of life lessons.
Yeah.
Along the way, playing that kind of sport at that level.
Any one big lesson that you think you can apply or have applied to yourself as a trial lawyer?
I think I was not the most talented player on the court. There were people who could jump higher than me, people who could run faster than me. But I really learned that with hard work, that you can accomplish your goals, that dedication, playing even when you're tired, playing even when you're hurt, and working towards a goal,
Sure.
I think those are really important life lessons. Also, time management. When you play competitive athletics, it's a lot of a time commitment. And to be able to do that in your schoolwork and all the other things that you do, as you know, when you're a lawyer, it doesn't stop the rest of your life. So you have other commitments. I'm a parent, and I still play a lot of sports. And to be able to make sure you manage your time efficiently to get ready for trial.
I can appreciate that. When I played sports, I wasn't the highest jumper or the fastest. I used to tell people I was more cerebral.
You were cerebral, yeah.
I
would tell people I was the workhorse, not a show horse.
I got you.
Yeah.
So talk to me about the areas of practice. I mean, I've had different trial lawyers on here, and all of us kind of have our own sort of specialty. I don't know that the consumers and the people in the community necessarily realize that lawyers have specialties, just like doctors. But what are your areas of expertise?
So I'm a medical malpractice lawyer primarily.
Okay.
That is what I enjoy. It's what I do the most of. So 95% of my work is medical malpractice. I still have some product liability cases, some premises cases, but the vast majority is medical malpractice. And I'll do everything from failure to diagnose cancer cases, from wrong prescription kind of cases, mismanagement of various medical issues. But I really do love learning the medicine and getting down deep into it. And then, having to cross-examine somebody cross-examining a neurosurgeon is a lot of fun.
Well, I'm curious, why med mal? How did that become your area of focus? Why are you so passionate about that?
So I started out my practice at Sutherland, Asbill & Brennan, a big defense firm where I was doing, RICO stuff and product stuff. And a case came across our desk where I represented, y'all remember Eckerd's, that's not around anymore, a pharmacy. And it was a medical malpractice case. And I just really enjoyed learning at that case. And also I decided I was on the wrong side. I was doing defense work. I did defense work for about 4 years. And so I made the switch over to plaintiff's work and just slowly got more and more medical cases. And then when I was, I guess, about to turn 40, I decided to go back to school. And I went and got a master's degree in public health. And so that I studied patient safety, medical errors, ways in which hospitals and doctors' offices can do better to prevent injury. And so from that extra education that I got, it just gave me more depth in my ability to represent people who have been injured by medical negligence.
I understand. Talk to me and about medical malpractice, and just kind of simplified in layman's terms. We get a lot of calls from folks that think that they have a medical malpractice case, and they're not really sure. And so just talk to me about sort of the basics of medical malpractice. What is medical malpractice, and how does someone know if they have or might have a viable case?
Well, so as we go about our daily lives, you understand that if somebody runs a red light while they're driving, they are negligent. If somebody, leaves stuff on the floor in a grocery store, they might be negligent. But people who practice a profession are held to a standard of care for practicing that profession. Lawyers are, doctors are, nurses are, architects are, all these professions. And when you do practice a profession, you have to adhere to a standard of care for that profession. And so a medical negligence case is a case against a doctor or a nurse or a hospital when they have not their care has not met that standard of care. It's different from other cases because in order to, nobody has to come in and give expert testimony about whether somebody ran a red light. But in order to proceed in a medical malpractice case, you have to have expert witnesses who come in and say, this is what the standard of care is for a doctor. If somebody has, I just had a C. diff case, somebody has C. diff, you have to give this medication. If somebody's blood pressure is this, you have to do this. So it requires this extra level of evidence, which comes from expert witnesses. So it's a lot of times it's very difficult for people to know if the doctors that have been caring for them have complied with the standard of care. But I tell people if the outcome they have from whatever it was that they sought treatment for is not within the realm that was expected. If you go in because you're having a baby and you end up, on a ventilator, there's a good chance that something in there went wrong, or there is a chance. And it takes lawyers taking a look at it and having expert witnesses to see if something went wrong in the care. A lot of times the professionals won't tell the patient. Some professionals will say, this was not supposed to happen.
And what sort of what separates you from other trial lawyers? What makes you sort of an expert in the field? Is it your really deep knowledge of the medicine? Is it the fact that you've had so many cases in this? I mean, how do you what makes you an expert as a medical malpractice lawyer?
So because and I think it's not necessarily a bad thing, but because professionals you probably have heard, professionals don't like to get sued. And so there's a lot of extra legislation, a lot of law around these kind of cases that aren't around other kind of cases. In other words, there's hoops you have to jump through in order to bring a medical malpractice case that you don't have to bring. You don't have to have when you're bringing a premises case or a car wreck case, for example. And so my extra knowledge in the law about how to bring these cases, I think makes me an expert. The other thing is I do have a great deal of expertise around how to read medical records, how to understand just basically the jargon that, doctors use. I can read a medical record and understand it. And third, I have a stable of experts who I can call on who might be, nephrologists or neurologists or orthopedic surgeons and all those kind of specialties that I can I know and I can say, can you read this chart for me and tell me, did this doctor comply with the standard?
I see. Now, I think one of your goals is to actually improve the quality of medical care.
Sure.
Is that right? So can you explain how you as a trial lawyer, not as a doctor, not as somebody who's actually in the medical community, are able to effect change and improve the quality of medical care for people?
Well, I think it's all about shining a light on what happened. And oftentimes when patients come to me, their loved one died or they've got this condition that they didn't expect and they don't know what happened. And so when we bring a case, we oftentimes highlight for a hospital, for a doctor's office, for an individual practitioner, where did you go wrong in this and how can you prevent that from happening in the future? Many times when clients come to me, that's their main goal, is they want this not to happen to somebody else. And so we shine a light on that, and it's through the discovery process, it's through taking depositions where we get their policies and we say, well, we end up at trial and we'll say, these policies are not, they don't keep the patient safe. So we've had cases, I had a case settle a couple of years ago, and at the end of the case, the doctor asked my client, can I use what happened to you in our teaching programs at this particular institution? And of course, the client was more than happy to let that happen. So we hope we shine a light and help hospitals, doctors, nurses do better.
That's amazing. Is there, do you see in your practice, are there sort of more common types of medical malpractice issues that come up, or is every case really highly unique?
You see a lot of things come up. I tell people you have to be an advocate when you're in the hospital, when you're in a doctor's office. But a lot of negligence happens during handoffs. Right? When one doctor is handling one piece of it, another doctor is handling another piece, and they're not communicating with each other.
I see.
I guess just like in a lot of situations, communication between providers is not what it should be, and things fall through the cracks. But my practice is I've got stroke cases, cancer cases, all kinds of them, but oftentimes that's an underlying what we call a systems failure.
I see.
Where there is not a good system for communicating important lab mechanisms, telling one person what another person is doing. So oftentimes we see that a lot in the handoffs.
I see. Is there one particular case that really stands out to you as a med mal case that you kind of can share that where it's instructive on what happened and sort of how you as a trial lawyer were able to help your client?
So I was just debating whether to talk about one that's currently going on or one that we concluded. I'll talk about one that we recently concluded. Okay. But in that case, the client had come in after he had fallen off of a horse. Really active guy who was out riding his horse, had fallen and had an injury to his neck. And he was originally in the ICU and was getting very good care, and then he was transferred to a lower level of care. The nurses didn't tell the nurses at the other level of care in the regular floor what they had been doing regarding doing serial abdominal exams, checking the person's abdomen. And the person got their intestines stopped working, which causes what's known as an ileus, and a backup, as you can imagine, would happen. It backed up, and nobody was examining the patient's belly. And because they weren't examining the patient's belly, he ended up vomiting, ended up aspirating, which means that when he vomited, some of that went back into his lungs, and he died right there in the hospital. And after that case, and after we were able to get it resolved, the hospital changed their training manual. And in the training manual now, the nurses had to, check that they had done these serial abdominal exams on a regular basis for people who had these kinds of injuries.
I see.
So that's an example.
But that's amazing. I mean, just the profound impact. So it's not just helping to secure sort of justice or compensation for your client, but really making changes that will help many other patients in the future.
Right. And also, we just believe that when doctors are held accountable, when any professional is held accountable, they're going to be more careful when they're taking care of people. If there's not lawyers like us that are the backstops to hold people accountable if there weren't lawsuits, then there wouldn't be anything that would, make sure that patients are safe when they're being cared for by professionals.
So true. I want to come back. You said something that piqued my interest, and you were talking about patients needing to be their own advocate.
Right.
Talk to me about that.
Oftentimes we find that doctors or nurses tend to sort of ignore the patient and not tell them what's going on.
I see.
And patients need to ask. Why are you giving that medication? And if they give you some answer that you don't understand, you say, no, explain this to me in layperson's terms. This is to help this person's blood pressure. This is a heart medication. Because so many times, if you just understand what is being done, then you can assist in this communication problem. Not always. Most of my clients, the caregivers are there, the family members are there. But just ask, I tell people, just ask questions. You have every right to ask your doctor. Sometimes people are nervous about asking. You have every right. You're a consumer.
Sure.
You're a consumer of that medical care, and you have a right to understand what it is that is being done. And you also have a right to ask for alternatives. One case I had recently, they did a certain procedure, and there was a safer alternative. They never offered that to this particular client, and that was below the standard of care, not to offer a different alternative. So, I just tell people, ask your doctor what they're doing and why they're doing it, and if there's another alternative.
That makes sense. Now, I know that medical malpractice is your primary area, but I also know you've done some great work in product liability, wrongful death, and also, I don't know if it's a specific area, but against big tobacco.
I did, yeah.
So let's talk about that. You good talking about that?
Oh, yeah. I love that type of work that I did for a while.
So, and you secured a huge verdict. I think it was about $11 million.
$11 million verdict, yeah.
So let's talk about that. So tell me what kind of case. Talk to me about, what kind of case that was.
Yeah, so very interesting. The fight against big tobacco has been sort of just an absolute success story for plaintiffs' lawyers because it was really plaintiffs' lawyers who got in and were just dogged against these huge companies that would not tell them anything. And it started back in the 90s with lawsuits in Florida and some other places where they were stonewall, and finally it was just chipped away. And that's why this treasure trove of information that we now know as to how the tobacco companies misled the American public. There is just everybody today, people younger than me that think, well, even me, that think that everybody always knew smoking was bad for you. But that's just not the case. And so back in the 1990s, a class action was brought in Florida for all smokers in Florida. It's called the Engle class. Went all the way up to this Florida Supreme Court, and eventually every smoker in Florida had the right to bring individual lawsuits. These are called the Engle classes against big tobacco companies. All of these cases were about smokers who smoked or began smoking before the warning labels were on the packets. The warning labels went on the packets in the late 60s. So my client started smoking when they were 15, 14 in the early 60s, late 50s, and got addicted. They were being told by the tobacco companies that nicotine was not addictive. It is massively addictive. And tried to quit. So these cases are against these big tobacco companies for individual smokers' damages. I probably did, I think I did 12 of them over the course of about a 10-year period as first chair. And really, it was just some of the best work as a trial lawyer because it was against some of the best lawyers in the country.
Wow.
The tobacco company, they have more money. Tobacco companies, they have just and they'll spend just millions of dollars to defend these cases.
And so how did you, were you handling those cases on your own?
No, I had a team.
Okay.
We had a team of 3 law firms.
Wow, okay.
And the 3 law firms worked together on all of the cases. And then the cases I led the trial team.
I see.
And then another lawyer, he would lead a trial team in some cases, and I might be a backup for him. But I led a trial team on these cases, and we had, staff and everything. But